Yes, sir.
Okay.
Oh, Kohima bin tulay.
এখন Kohima বাইদেউ কবিতা এইখন আমি ওলাই এইখন চিটটো কি আমাৰখনে ওলাই বেলেগ ফটো হেৰি চলি আছে
Okay, sir. I will.
কি মেক্সিমাইজ কৰিব নোৱাৰি নেকি
Take it to Kohima ওলাই।
ওলাই আছে
আমাৰটো নহয়।
নহয় চাউল কি ফটো আছে আপোনাৰ
In.
এইতে
চলি আছে। ৰখি যায় মানে। Order system.
একদম কাম করছে
Night বলে যে 95 এই উপর ডাইরেক্ট
একেদিনে দিগদার আমারও দিগদার হয়ে
Hello,
যায়
check. Are you audible?
Yes.
Thank you.
বাইদেউ আমি রেডি লট Hindi ito tipo very pure of but hello apa idea হ'ব কৈছে বাইদেউ হেৰি চিংগল বেঞ্চ বহিব এতিয়া এডভকেট এই পিপি আছে ইটো চাইডৰ নাই আৰু কি হৈছে ন বাইদেউ নাই আছে ন এই পঠিয়াই দিলে হেৰি কৰিবা এইটো কি বুলি কয় 425ত যাম বা মই গৈ লৈ ল'ম
বাৰ মিলাই লগাই পৰা
কালি
তাকে ঠিক আছে।
Belajar diskusi lah.
Good morning, Lordship. Delivery of order item number 1, bail application 3789 of 23.
Petition is rejected. Rejected.
Thank you, Lordship.
Complete.
May I please, Your
Yes,
Lordship?
yes.
May we please to mention item number 7, Your Lordship?
Item number 7.
Yes, Your Lordship. Your Lordship, here I have received instruction in respect to respondent number 2. However, I have not received instruction from 3, 4, and 5. So, Your Lordship, in this regard, another 3 weeks may be granted to me, Your Lordship, for receiving instruction and for filing counter affidavit.
Government advocate.
Yes, Your Lordship.
Learned government advocate, Miss So-and-so, has some prayed for adjournment as she has not received instructions from respondent number
3, 4, and 5, Your Lordship.
3, 4, and 5. List them at, all right? Learned counsel, Mr. So-and-so is present for the petitioner. List the matter after 3 weeks.
Yes, Your Lordship. Much obliged, Your Lordship.
Yes.
Yes, Your Lordship.
Mm.
Your Lordship, I beg to mention item number 4.
Mm.
Lordship, I may be allowed 3 weeks time to file my reply.
Learned counsel for the petitioner, Mr. Friend, so with the consent of the other side has paid for adjournment, list the matter of paid for adjournment to submit his affidavit in reply. List the matter after 3 weeks.
Much obliged.
May I please, Your Lordship?
Mhm.
I'd like to mention item number 12. I received
4?
Item number 12.
Sorry,
Item number 12.
12. Okay.
Yes. Your Lordship, I received instruction to represent respondent number 2.
Respondent number 2.
Yes. Your Lordship, kindly grant me 3 weeks.
Learned counsel for the respondent number 2, with the consent of the other side, has prayed for adjournment. List the matter after 3 weeks.
3 weeks.
Lordship, moreover, by IA 2 of 2024, this honorable court was reduced enough to allow the petition and complete one more respondent this treated as a global university. The service upon the respondent 3 is yet to be completed.
Service report on respondent number 3 is awaited.
Awaited, Lordship. Lordship. Very obliged.
My please, Your Lordship. Lordship, I beg to mention item number 8.
Yes.
Lordship, we are from respondent number 5.
Hmm.
So we are yet to file our affidavit in opposition, so kindly grant us 3 weeks time.
Lordship, one objection. Lordship, the petitioner is challenging the amendment of progress respondent number 5 on the ground that the amendment was made without any selection and violation of the constitutional mandates of public government. Lordship, considering the urgency of both of this petition, because the public voice has been held illegally by respondent number 5, this court on 21/9/2023
Record.
First, in order to effect that which shall be made to dispose of the petition and then demonstrating about it. Now, the proper respondent enter evidence on 16/10/2023. Now, they are slaving over the matter, they are trying to delay the matter also. Therefore, my prayer is, last chance may be given, and do affidavit is filed by next available date. The case may be disposed of based on the available records.
All right. Learned counsel, Mr.
Abel, IME.
Abel,
IME,
IME, on behalf of respondent number
5.
5, has prayed for adjournment. Learned counsel, Mr. W. Zamir,
Yes.
on behalf of the petitioner, has raised serious objections stating that that this case has been delayed and the respondents have been sleeping over their rights. I have considered the objection raised by the learned counsel for the petitioner. A last opportunity is afforded to the respondents to place their matter on record, list the matter after 2 weeks,
Lordship, can you grant us 3 weeks time?
list the matter after 3 weeks. And on the next date, this petition will be taken up and disposed of on merits. No further adjournment will be allowed. All right? Oh, no. All right, then on the last day to cut it here. Oh, cut do. Just strike it off. On the last day, this petition will be taken up and disposed of on merits. A last opportunity is afforded, that will suffice. All right.
Lordship.
Thank you so much. Lordship, I'd like to mention hearing item 14, 15, and 16.
Yes,
Lordship, if the matter will be listed after 3 weeks.
yes.
Noted.
Learned counsel for the appellants, for the petitioners, Miss Sentiangar,
Only.
Miss Conley, with the consent of the other side, has prayed for adjournment, list the matter after 3 weeks.
Lordship, I have similar prayer for item number 3.
Same order.
There is an interim. There is an interim.
Interim. Do you have any objection? The other side, item number 3. Interim order shall remain in.
Let this be the last chance.
Okay, same order. The last chance is afforded. Interim order shall remain in force till the next date. Till then, interim order shall remain in force till then.
May I please, my lord? Lordship, item number 9. I'm yet to receive instructions, so can you grant me 3 weeks time?
Yes, do you have objection? Your name is not on the cause list.
No, for state, K. Angami, my name is.
Okay, for the state, all right. Item number 9.
Yes,
Government advocate,
yes.
learned government advocate, Mr. K.
K. Angami.
K. Angami, with the consent of the other side, has prayed for adjournment. List the matter after
3 weeks.
3 weeks.
Interim order passed today.
Interim order shall remain in force till then.
Lordship allowed me to mention criminal revision 10/2018 for listing day after tomorrow. Here I want to pray for passing the appropriate order. The original reports are with this honorable court, and some of the reports are required for further investigation. So
On Thursday,
Thursday, I have mentioned.
I can allow. I think you'll have to mention before the senior bench.
I think for that it's okay. I think just for listing. I have mentioned the more also.
For listing, can I allow, or should he mention before the senior bench? Huh?
Yes,
I can allow. All right, because
yes, I understand.
I'm very new to this area, so I don't know.
Pleasure.
Day after tomorrow, not on Friday, okay?
No.
Day after tomorrow on Thursday.
May I please?
Mm.
Lordship, I beg to mention item number 13.
Mm.
I have instruction to appear for respondent number 1, Lordship, in this matter. If 3 weeks' time can kindly be granted to me to receive instruction, Your Lordship.
Learned Counsel, Mr.
In Angami. Your Lordship.
N. Angami has prayed for time to obtain instructions to appear on behalf of the respondent.
Number 1.
Respondent number 1, Miss so and so is present for the petitioner. List the matter after 3 weeks.
Service report on respond number 2, 3, and 4.
Service report,
awaited.
respond number 2, 3, and 4 is awaited.
DP, Your Lordship.
Item number 20. 20?
220.
20. Oh, we have 20 items only, yes.
Lordship, if this matter can come up next week,
Learned Counsel for the,
respondent, state respondent.
or learned government advocate?
Yes, Lordship.
Mr.
Visual.
V. Jumomi, learned government advocate, learned, Mr. V. Jumomi, with the consent of the other side, has prayed for adjournment. List the matter after 3 weeks.
Lordship, next week.
Next,
List the matter after, list the matter on
4th March. Lordship.
4/3.
4th March. Pleasure.
May this Lordship, Lordship, I beg to mention item number 1 and 2. On behalf of additional AG, V. Supreme.
Additional?
Additional AG, V. Supreme.
Okay.
Lordship, can you list this matter after 3 weeks? To produce compliance order.
Learned Counsel, Miss
Additional AG.
so and so on behalf of AAG. Mr. V, Mr. So and so, with the consent,
This be the last chance, Lordship.
with the consent of the other side has prayed for adjournment. The learned counsel for the petitioner has submitted that no more opportunity is to be afforded, as this case has been dragging on for a considerable period of time. So a last opportunity, a last adjournment is allowed.
Much obliged.
1 and 2.
for motion, item number 17.
So, Lordship, this contempt petition is filed for non-compliance of orders dated 1990. The report was issued by the state respondent directing for recovery of excess role of a Lordship. So, Lordship, here the Honorable High Court by order 9/23 has a question saying no recovery order. However, till that case of petitioner has not been considered, Lordship. Hence this contempt petition, Lordship. Lordship,
Contempt against?
against the order dated 19 for Lordship, I have an excess annexure in.
So you issue notice then? This is at the motion stage? All right. Learned Counsel, Miss so and so is present on behalf of the petitioner who has filed this contempt petition. The petitioner to take steps to issue notice to the contempt respondents. Through registered post,
Lordship,
as well as through usual process, returnable within 4 weeks,
Lordship.
list accordingly. 3 weeks or 4 weeks?
3 weeks, Lordship. It's a pension matter, Lordship, so
3 weeks, yes.
much obliged.
For motion, item number 18.
Yes, Your Lordship. Your Lordship, the instant application is filed seeking for compassionate opinion. The petitioner's father, late father died in harness on 28/10/2021 while serving as sectional assistant under PWD Housing Chantumya Division, Mokchung.
Died, when did he die?
On 28/10/2021.
Okay. So did you directly proceed, directly approach the,
Yes, Your
Government?
Lordship, I have
but they did not allow?
yes.
So
Your Lordship, I have made an application to the chief engineer on 16/11/2021.
However, no response has been made.
So you have made him a party?
Yes, Your Lordship.
Okay, then you will have to issue notice then, oh, he's already here. You have for the, both the sides, only for the state. State and other respondents also. The chief engineer is also the respondent here.
No, I'm responding, the respondent number.
One and two.
Yes, okay. 1, 2, 3, 4.
1, 2, 3, 4, all of them. So then should we take down the submissions of both the sides, or you want?
No, ma'am, Lordship, at this stage, notice can be issued.
You have received notice?
No,
You haven't received? 1, 2, 3, 4, nobody has received notice.
no.
You want a formal notice?
Yes.
All right. Heard Miss
Conley.
Conley, learned counsel for the petitioner, and the learned counsel, Mr. So and so is present on behalf of all the respondents. Petitioner to take steps to issue notice to the respondent through register post as well as usual process, returnable within 2 weeks or 3 weeks.
4
Return-
weeks.
Huh?
If it's.
You are here already. Why do you want 4 weeks? 3 weeks, 3 weeks. Returnable within 3 weeks, list accordingly.
For admission, item number 5.
On the last occasion, this one report has given a direction to the respondents on write down the status.
Okay, okay. Relating to what?
Considering the petitioner's case for
What?
regularization.
Okay, okay.
Also, there's a direction by this honorable court by disposing a read petition lodging on 13th of May 2023 lodging. 3 months time was given lodging. Now more than 11 months has lapsed lodging. The respondents are yet to consider lodging. My respectful submission is that lodging. If the respondents fail to consider lodging, their personal appearance may be called for lodging and to explain why the circumstances why they cannot consider my case lodging.
Yes, sir.
Yes, Your Lordship, we are taking the initiative. The communication letter. It was written on 21 February.
Sorry,
Lordship will file.
contempt petition.
Yes. Lordship will file. The consideration of the petitioner is in serial number 8.
Serial number 8.
Serial number 8.
Serial number
8.
8. One post of carpenter grade 1.
Yes,
Creation of one post
yes,
of carpenter grade 2.
yes.
Grade 2 for regularization to the incumbent under the establishment. So post has been created. For regularization, the post has to be created.
Lodging.
So post has already been created. So we'll close this matter then.
Lodging, they may be given a direction to regularize lodging. Or maybe sometime maybe given to the justice, complete the report lodging as to what will be the division.
Post has already been created.
Yes, lodging, but it may take time lodging.
Contempt petition number 9 of 2023. Sri Marwati Longkumar versus State of Nagaland. So with reference to your letter cited above, I have the honor to forward here with the PNAR Department Circular. The meeting of the Manpower Rationalization Committee to examine the proposals of various departments will be held on 1st February 2024 in the Chief Secretary's conference room. So maybe the meeting was held, I think.
It's lodging. It was scheduled on first step. They may be allowed to apprise as to the time frame for considering my case for regularization. Of course, there's a document that shows that they will initiate for creation of post, Lordship. But of the creation of the post, within how much time they can consider my case for regularization? If they may be allowed to apprise the time frame, Lordship. Otherwise, it will delay, Lordship. And Lordship, I kindly appreciate I'm retiring in the month of September this year. So it will not serve any purpose, Lordship, if it was beyond September. And this petition has been pending nearly for a year, Lordship. So contempt petition is not supposed to be pending for quite some time, Lordship. It has to be disposed of expeditiously, Lordship. This shows that they have no regard with the direction of the Honorable Court. And the matter was kept pending for 11 months before I approached by way of this contempt petition, Lordship. Even after filing the contempt petition, Lordship, considerable amount of time has elapsed, Lordship. They should come with a clear instruction as to the time frame. We don't know how much time they can consider my case for regularization.
Is it okay? Is it okay?
Lordship, as I was saying yesterday also, that in the aspect of the regularization, there are certain total procedures that has to be followed. It has to go up to the extent of the cabinet. It has to go to the government and then
The post has to be created, then the funds have to be identified. Funds have to be segregated, post has to be created. It will take some time, it will take some time, but from the ministry level, not from the ministry level, from the secretariat, you will get the number of posts on which has been created.
But if the matter may be kept pending, meantime, they can process for considering my case, Lordship.
All right then. Matter will be kept pending. Heard Mr. Mua Imchen, learned counsel for the petitioner. Mua Jamil, learned counsel.
Both are more. One is more Jamil,
Okay, sorry.
Lordship, I'm representing respondent number 4.
That's not about.
My friends are representing the others.
and for respondent 2 and 3.
2 and 3. You write down the names accordingly because I'm mixing up the name. Mua versus Mua. Heard Mr. So-and-so, learned counsel and everybody, huh? Write down the names. Respond number 1, 2 and everybody. They, yeah, for the government, no? Government of Nagaland. The respondent has submitted that a post has been created and the circular dated 31/2024 number AR-3/GEN-331/16 within bracket volume 2, not figure, huh? Roman 2, bracket close. With the annexure reveals that a post has been created for regularization of the incumbent, Sri Marwati Longkumar. So what is the point of keeping the pending? I do not understand. Post has been created for her.
Kindly apprised whether this is for proposal for creation or they have already created, Lordship.
And this is the proposal for creation. No. Post has been created.
Lordship.
Creation of one post. No, a meeting will be held. All right then. You are right then. A meeting has been held for creation of one post. Post has been created, no. Not post has been created. A meeting is proposed to be held for creation of one post for Srimati what else was her name? Marwati Longkumar. The learned counsel for the petitioner has submitted that the petitioner is to retire in the month of September, and the respondents have taken procrastinated the regularization process, most of the regulation is still under process, and instructions may be obtained by the respondents relating to the fact that if the post has already been created and if steps have been taken for compliance of the order of this court
Lordship,
or some other court, order of this court dated
13/05/2023.
13/5/2023 in connection with 13/5/22 in connection with WPC number 281/2021. List the matter after 4 weeks.
Lordship,
It will take some time.
Lordship,
Pleasure.
obliged.
For admission, item number 6.
So nobody is present for item number 6. Parties are not represented today. List them at, oh, you are here.
No,
Item number 6.
item number 6. The last submission.
Parties. This is an AB.
Lordship.
Okay.
However, Lordship, by an order dated 29/1/2024, Lordship, this honorable court has passed an order.
Interim order.
Lordship, that has been cancelled. Interim order has been
So
cancelled.
interim bail was granted.
Bail was not granted.
Bail was not granted.
Lordship.
29/1/2024.
Yes, Lordship. In the month of January.
So I'll cancel the bail then. It has been cancelled.
Lordship, it has been cancelled.
Cancelled,
And
okay.
now the matter is listed after 4 weeks to get the necessary instruction, Lordship. Now, what happened on 2nd February 2024, Lordship? The IO investigating officer of the present case has has approached the JMFC Dimapur for issuance of non-bailable warrant of arrest, Lordship. However, now the accused is on run.
Absconding.
Absconding,
Accused is absconding.
Lordship, and yet to be arrested, Lordship. So if this matter can come up after 3 weeks. Lord.
Okay. The learned counsel for the petitioner, the petitioner is not represented today. The learned the learned PP, Mr.
Vijumon.
V. Jumomi is present. It is submitted by the learned PP that earlier by the order dated 29/1/2024 interim the interim bail order or the interim bail granted to the petitioner, who is interim bail granted, petitioner or the accused.
Accused, alleged accused. petitioner.
Petitioner is the accused.
Petitioner is accused.
Petitioner stroke accused has been cancelled and IO was directed to take necessary steps to arrest the accused. And this matter was listed today for instructions. So it is submitted that NBW has already been issued against by the court. So this case is pending in the court by the
this matter is
jurisdictional
still
court.
pending.
NBW has already been issued by the jurisdictional court against the petitioner stroke accused. The accused is evading arrest and is absconding. So we can close this matter also. You have the CD?
Right now, I don't have a CD. However, through verbal instruction. So if this matter can come up after 2 weeks so that I can place.
The
the form.
Learned PP has further submitted to
To place the instruction.
place the instructions
Lodge.
in compliance of the order of this, the court dated 29/1/2024. Huh?
Lodge.
3 weeks time.
Lodge.
3 weeks time to obtain instructions in compliance of the order dated 29/1/2024. Accordingly, 3 weeks time is allowed. List accordingly.
For admission, item number 10.
Please, Your Honor. My lord, by order dated 12 February 2024, 10 copy of the CD has been called. This honorable court was pleased to grant that interim anticipatory bail that day.
Do you have the scan copies of the CD? Yes. Yes, what do you have to say?
My prayer before this honorable court is that the anticipatory bail may be regularized because the applicant has been fully cooperating with the investigation. He has given his statements before the police, and this is a clear case of a false and frivolous FIR being filed against the present applicant. The informant, the FIR informant, she is in the habit of making such allegations against her previous husbands, and then she'll honey trap men and make such false FIRs. I have also enclosed the necessary documents.
Where's the FIR?
The FIR is at page 51. Type copy starts from page 54.
What do you have to say?
Lordship, may kindly come to this is the progress report, Lordship, submitted by the IO. Lordship, may kindly come to the last page of the progress report. The operative part is third paragraph.
Yes.
In the course of investigation on 9/2/24, issued police notice under section 41 CRPC to the complainant for the forwarding of a statement under section 164 CRPC, and even issued notice to her mother, Vimal Sharma, brother Rajiv Sharma, and sister-in-law, Kamal Sharma, but via report for completion of police investigation. It is also mentioned that an investigation is to be completed, and even the alleged accused, the present accused, Dr. Sundar Lal Parik, is fully cooperating with the investigating agency, and so far, no further custodial interrogation is required.
So not required, I think.
No. So now the investigation is over.
I was heard at length on 12th of this month, while granting this interim anticipatory bail, my lord.
Heard Mr. Sentianga,
My lord.
learned counsel for the applicant, and Mr. Jimomi, no? V. Jimomi, learned addition learned PP Assam, or learned PP, sorry. Nagaland, Learned PP Nagaland, the petitioner, Dr. Sundarlal Parikh has filed his application under section 438 CRPC with prayer for pre-arrest bail as is apprehending arrest in connection with women PS case number 2 of 2024 under section 498A by 376 IPC. It is submitted at the bar that the petitioner was in a live-in relationship with the informant since 18/1/2023 to the knowledge of the family and relatives of both the petitioner and the informant. So, however, surprisingly, on 14/12/2023, the informant lodged an FIR with the police at Dimapur, alleging inter alia that she was forcefully sexually abused at Connaught Palace, New Delhi on 18/1/2023. It was also alleged that the petitioner forcefully committed theft. Petitioner forcefully took custody of a baby from Nikos Hospital, Dimapur, and subjected the informant to mental and physical cruelty to meet his illegal demand of dowry. So, it is submitted on behalf of the petitioner that a false case has been slammed against the petitioner, and the informant is in the habit of making such allegations against other men. I've considered the submissions at the bar with circumspection. The scan copies of the CD was called for. Progress report was forwarded by the IO. It is submitted by the IO through the progress report that the investigation has progressed to a considerable extent. The petitioner has cooperated with the investigation. The petitioner was on interim bail by the order of this court dated 12/2/2024. Considering all aspects and considering the fact that the petitioner has cooperated with the investigation, I deem it proper to to grant bail, anticipatory bail to the petitioner. I have also considered the submission that the petitioner is willing to cooperate with the investigation. And the petitioner will not, and the petitioner will abide by any bail conditions if imposed upon him. Considering all aspects, the interim order dated 12/2/2024 is hereby made absolute under the same terms and conditions imposed upon the petitioner by the order dated 12/2/2024.
Keep your place.
For orders, item number 11.
Lordship, by the last order, the registry is to track the notice sent to the respondent number 7.
If it pleases the court, your ladyship, I appear for respondent number 7 through VC.
Yes.
Grateful, your ladyship. Grateful.
So all the respondents are appearing today? No.
I believe so.
Additional affidavit filed on behalf of respondent number 1 to 3.
Yes, I am appearing for respondents 1, 2, and
1
3.
to 3.
I have raised preliminary objections regarding the maintainability of the writ petition.
Okay.
My lord, because here they are claiming for compensation and they are disputed question of facts. Facts needs to be settled. And there is an alternative remedy under the law, a statutory remedy. So as per the decision passed by the Honorable Supreme Court in 2022 SCC online as
Just a moment, everybody is appearing. Respondent number 1, 2, and 3, you are for respondent number 1, 2, and 3. Then for respondent number 4, 4, 5, and 6, and the last respondent is respondent number 7. Okay. So, affidavit has been filed by all of you.
Yes,
Ah.
it has been filed by all the respondents except.
And respondent number 7 is appearing today. So we'll place this matter for admission, or should we take up the matter today itself?
Lordship, this is the matter pending since 2018. When the construction was started, all my properties have been damaged. For that reason, several representation has been made to the respective authorities. But for that reason, since despite of all these representations, no response have been made. So ultimately, the petitioner has left with no other options. They have come before this court. Lordship, coming to the claims of the petitioner here. See, one of his private residence, which is under construction, was totally damaged. His road has been cut off. Then the petty fields from which they are getting their source, that also has been affected. They are not only that the pedigree funds, they are also there in the now in the subject matter. That was also affected. So for that reason, we have written several representations to the respondent authority. That was not done. And finally, of course, during the pendency of this case, now on the latest development, that is on 20th of February, 20th of February 2024, joint verification was done in the presence of all the parties. Even the NHS is here today, he is raising some preliminary objections, but his party is everyone present, as convened by the Deputy Commissioners Kohima. So now the damaged properties that will be properly assessed and it will be sent to the authorities who to pay the compensation amount. That is now the developments that we have. So the only thing is to
Only 1, 2, and 3 is raising objection.
Your Ladyship, I also have a submission to make if your Ladyship permits me. Your
Yes.
Ladyship, this is a dispute between the petitioner and R1 to R6. And this matter is prior to 2017, I was only a contractor in 2022. Only one letter has been written to me, admittedly. And I have no role to play here. I had told them that whatever the government does, I am okay. It is beyond my scope to do anything for you. Except for that one letter, there is no prayer against me. There is nothing against me, your Ladyship. So, your Ladyship, as an officer of the court, it's my duty to inform this court that I'm not a necessary or a proper party in this matter. I have been impleaded by the petitioner. If this court permits, I may be permitted to be deemed pleaded. I may file a reply only to add to the voluminous court records, but I want to make these submissions and check if the petitioner has no objection. I may be deemed pleaded. He's got no relief against me at all, your Ladyship.
I agree.
So he has also agreed with it. So do you have to file an affidavit?
Your Ladyship, if your Ladyship says that I have,
that he has no grievance against you.
then no difficulty, your Ladyship. Then I want to, your Ladyship may kindly record in the order and deem plead me. There is nothing against me. I'm not a party important for this adjudication at this stage, your Ladyship.
All right.
I'm most grateful, your Ladyship. Most grateful.
Absolutely, what is submission? I'm nothing against you.
I'm grateful, your Ladyship. I was just an innocent contractor who happened to be there, who did not even break or cause any damage to his property. I came much later. I've already left that contract. I've been deemed pleaded in that contract also. That contract is terminated. All that.
You have come you have come later.
I just received the summons this a week back, your Ladyship.
Number 7 was not involved in the contract.
No, nothing, your Ladyship, nothing at all. There was a contractor called Gauhati there, who actually through his actions caused any damage to the petitioner and nothing to do. Nothing, no, there is no adversariality we're not adversaries in any manner, Your Ladyship.
Prior to the respondent number 7, who coming to for the contract, that the Gayatri they work that was ultimately left or more or less terminated. Then the OSS, the respondent number 7 came, but that also been left. And now the new contractor has come and in that stretch of road. So in fact, in a way, having the petitions, I have nothing against the respondent number 7. That is how, see, initially the notice was returned unserved. Still then we were not insist on it. But in between, somebody has raised that all the parties have to be there. So in order to complete the formalities, only that
only to complete the formality.
Respondent number 7. So I fully agree with him. I don't have any.
In that case, Your Ladyship, without adding to the burden of this court, if Your Ladyship may permit, I may be deemed pleaded. My learned friend has no objection as a petitioner, and I can rest my case here, Your Ladyship. Nothing adversarial here.
Your submission is taken into consideration.
I'm most grateful, Your Ladyship. I'm most obliged, most honored.
Yes.
I may be allowed to make a brief submission on the
Yes.
preliminary objections that I have raised. Now, facts needs to be settled in this instant case because the petitioner on the one hand is saying that his RCC building has been damaged, his approach road has been damaged, his paddy fields has been damaged, his piggery farm has also been damaged. So for this assessment, proper assessment is required. Now,
so according to the petitioner, that proper assessment will be made. That is what he's saying.
yes, that is why he needs to approach the civil court. I'm not saying he does not have a case, but this court is not the appropriate court. That is what I'm trying to.
Yes, actually, this is a road construction. Due to the road construction, your property has been acquired.
Lodge.
Property has been acquired.
My property, part of my property has been acquired. I'm admitting that the compensation has been paid.
Paid, yes.
However, beyond ROW, beyond the land that has been acquired by the respondent authority, see that during the constructions took place, that my property is beyond ROW has been affected badly. And that also see, in a way, my shelter that has been affected. The paddy fields from where, the family is surviving also have been affected. My fundamental rights and also the rights under Article 300A that has been violated. That is how I'm before this court. And my prayer also limited, go by the petitions, my petition, that to make proper assessment and pay the compensations if I decide or if I'm entitled for it. That's all. Limited prayer.
May it please, my lord, I may be allowed to place.
So according to you, this case lies in a civil court?
Yes.
Not under the WPC?
No. I may be allowed to place 2021 SCC online, Orissa 632.
Yes.
Paragraph 8 is the
Paragraph?
portion. Paragraph 8.
8, okay.
Considering the rival contestants of the parties and the interveners, coupled with the fact of pendency of the civil suit as noted herein before, it is clear that the present petition raises highly disputed question of facts, which would require the leading of evidence and the examination and cross-examination of witnesses, and which are therefore not amenable of being adjudicated under Article 2 to 6 of the Constitution of India. In Chairman Corporation of Orissa Limited versus so-and-so 1999 7 SC 298, it was held by the Supreme Court that it is settled legal position that where disputed question of facts are involved, a petition under 2 to 6 of the Constitution is not a proper remedy.
Yes.
Now, the next one, 2022 SCC Online SC 1262, paragraph 16.
Yes. Yes.
Now, so far as the reliance placed upon the decisions of this court by the learned senior advocate appearing on behalf of the respondent, referred to herein above are concerned, the question is not about the maintainability of the writ petition under Article 226 of the Constitution of India, but the question is about the entertainability of the writ petition against the order of assessment bypassing the statutory remedy of appeal. There are serious disputes on facts as to whether the assessment order was passed on 23/2020 or 14/7/2020 as alleged by the SSC. No valid reasons have been shown by the SSC to bypass this statutory remedy of appeal. This court has consistently taken the view that when there is an alternative remedy available, judicial prudence demands that the court refrains from exercising its jurisdiction under constitutional provisions. So he could have approached the civil court. There is no power for him to approach the civil court because assessment has to be done and cross-examination of witnesses, examination is required because it is only because there is a dispute, which is why there is a case. Otherwise, in the ROW that we have acquired, compensation has already been paid to him. Now he is saying that beyond the ROW, his properties has been damaged. So we highly dispute this fact. And for this, leading of evidence is required. And for this honorable court, under Article 226, is ill-equipped to go into. Therefore, my humble prayer is that the writ petition may be dismissed and the petitioner can always approach the civil court. Deeply obliged.
Civil court as a claiming damages. In what manner?
Damages,
So he has
compensation.
no, now he has no relief under this 2013 Act because he's already been compensated as road was constructed as per 2000. You are compensated under the 2013 Act, Compensation Act.
Yes.
So you are compensated.
Yes.
So
But
under the
how-
2013 Act, he has been compensated.
Yes, I'm not claiming any damage that has been done within the area that has been acquired by the respondent authority.
But outside the area.
Yes, but you see, outside the Lordship, then instead of it, may I take your lordship to the affidavit in opposition filed by the respondent number 1, 2, and 3. Here it is.
He has a point, but
Lordship, affidavit. filed by the-
this 2 judgments. He has relied on these 2 judgments. He has a point.
No, but lordship, coming to the facts of the case. How they have made it,
Affidavit by 1, 2, and 3.
1, 2, and 3.
Yes, yes.
Then paragraph 18. Paragraph 18. What they have made here.
Just a moment, para 18. Yes.
Paragraph 18. Specifically, may I read for all of us? Paragraph. That with regard to the statement made in paragraph 15, it is stated that the general manager, NHIDCL, PMU Dimapur White letter number such and such, dated so and so, 10/6/2022, and letter so and so, dated 15/9/2022, wrote to the respondent number 5, Deputy Commissioner Kohima, and requested to provide the details of disbursement of compensation in the said stretch and to notify a convenient date, that is from 11 to 14 June 2022 for joint site visit to identify the damage and losses of Sri Tejal Sekose, that is the petitioner, at Sri Colony Central Zunta for resolving the issue at the earliest. However, the same is still awaited. So that was, a letter was served by the respondent himself. to the deputy commissioner for doing verification to assess the property. Now only they are saying that the disputed question of it. Now, we went for the joint spot verification. So far, they agreed to the department, the line department has brought into the housing department, that PWD. Then agri department, horticulture department, forest department, then from the land survey department. All of them, they came, they did assessment. They were part of, so see, the respondent themselves were part of it. And accordingly, jointly, that assessment was done. Now only where is the question of disputed question of fact? Where is the disputed question of fact? If they say that no, this property is not damaged, but however, they have included. If such dispute has come, arises in future, yes, that has to be decided by the Supreme Court by taking evidence. But where is the question of disputed question of fact is there? Where they have disputed, anywhere they have disputed that this property was not damaged. If they're admitting, these are admitted liabilities. So we are asking for joint assessment, proper assessment of the damage. That is done. Now at the stage of just handed over to them to make a payment. They say after doing joint verification, they denied some facts where no, this property is not damaged because of this. Then only then disputed question of facts will arise.
Yes.
Bless your lordship. Your lordship, I represent the respondent number 4, 5, and 6. As the respondents. Actually, as far as payment is concerned, my part is very limited.
Yes.
Because I have to take the logistic support. That's only. And I have mentioned in affidavit resolution in file number 2 and 3. Because lordship here, the proximity of the alleged damage suffered by the petitioner. It's a quite remote.
You're for 5.
Yes.
4 and 5.
4, 5, and 6.
4, 5, and 6. Yes.
That is a step response.
So what is in the affidavit?
Your lordship here, in my affidavit, para number 2 and 3. The substantial question of law involving the civil extraordinary jurisdiction, whether the petitioner can make out the case or not. That's one question. The other thing is basing on the proximity of the alleged damage suffered by the petitioner. Then there is a glaring substantial question of facts, which can be determined by the due process of law. That's my only submission. Otherwise, my part is quite limited here. But the thing is, when we see if the damage suffered by the petitioner comes within the bureau of the ROW, then that's also okay. But it's a quite remote proximity. So that's why we have taken the blame that this has to be determined only by the due process of law. That's my only submission.
So you are, in a way, you are questioning the maintainability also.
Yeah,
Because substantial question of law.
Automatically.
So there's a question about the maintainability of this petition.
One respondent can take 2 stands here.
Now,
The state respondent themselves make an assessment. There was a damage of properties causes to the petitioner. That is how they themselves have convened the meeting, because in order to assess the property, taking cognizance of the claims of the petitioner, they have convened, done. Now, at this stage, saying that no, this court cannot take up this issue. What is that?
So this matter cannot be admitted also. And then you are insisting that this they have already agreed to compensate. So we will wait for some time then.
Lordship, that way, since assessment is now.
Assessment is going on according to you. But
Lordship,
according to
on the
them,
other- Lordship,
according to
on the
him
other-
also, he has no role to play.
Lordship, on the other,
Ah.
whether my fundamental right has been affected, this is one issue.
No fundamental rights.
Whether my fundamental.
300A is no longer in part 3.
Lordship, my fundamental.
The issue of fundamental right does not come.
Let me see.
Lordship,
Constitution, give me the constitution. 300A.
so.
300A, the right to property.
Right to life, what is right to life? Without shelter, person can live.
Article 30.
Without the agricultures from where they are surviving affected, is that affecting the fundamental rights of a person? The properties that the piggeries that have been, my piggery has been affected, is that okay, my livelihood has been affected?
If the
So Lordship, these are the issue. And see, if they themselves want their initiation. Even joint verification, this is not the only joint verifications we have conducted. Third time joint verifications conducted in different three occasions, in three different occasions.
Maybe I think
Some
some differences arose during the verification, maybe. Some differences arose between during the verification.
That is, we can wait for the outcome of that, the value assessment of it.
So that is why they are opposing.
And okay, after that only, the disputed question of tax will be.
According to him, I think the way both the
Yes.
parties are submitting now, I think some differences have arose relating to the compensation.
My fundamental right have been affected or not, and whether they are responsible for it.
He says no, your fundamental right has not been effective. That's what he's saying.
If the submissions made by the petitioner's counsel is accepted, my lord, the settled position of law shall be disturbed as
According to the
Yes.
Honorable
Yes.
Supreme Court judgment.
it's not that they don't have a remedy, they have a proper remedy before the civil court. And the petitioner's counsel have submitted that the last joint verification was conducted on February this month, but it is not on record and I have no instructions regarding the last joint verification.
That means his client has not instructed him properly.
But the last verification that we have placed on record before this honorable court, but I don't think.
And the judge. That means he is not properly instructed.
12, the last verification that is on record was conducted on 12th of July 2023. On that day only the land was surveyed, nothing else.
No,
Because
there was a verification done on 2024, recently.
is it on record?
Not on record, but he has given a copy. As per joint
Just now.
verification notice dated
That means
16
he is not properly
24
instructed.
issued by the revenue officers Kohima for assessment of, what is this? For assessment of damages, properties belonging to Sri Teja or Sekose. The following members were present at the and conducted assessment of properties
The
of
liberty may be given to the parties to place the document on record by filing proper affidavit.
I think you also ought to have filed an affidavit, at least an application, IA, for his name to be deleted. 7, now we have a recent
Yes.
notification of Gauhati High Court for amendment to our cost title and notification. Yes.
I'll do the needful, your ladyship instructs, no difficulty.
Because there's a notification being circulated that whenever you want to amend the cost title, you'll have to file an application for an amended cost title. You have to file at least an amended cost title. So if it comes to an affidavit, through an application or through an IA, then a proper order can be passed.
I'll do the needful, your ladyship, no difficulty, since I take the instructions, your ladyship, no difficulty. I'll do that.
Yes.
Before the next day of hearing, I'll do that.
Yes.
I'm obliged, your ladyship. Most
Okay.
grateful. Your ladyship may record my submissions and the fact that my learned friend is not objecting, and I'll move an IA accordingly and may be instructed to me. No difficulty. I'm most grateful, your ladyship, for the time. Honored.
So you want to go through this?
Yes.
It's the petitioner. His land has been assessed.
My lord.
So then we'll have to give you some time.
My lord.
Let it be settled amicably. Where is the problem? No, there's no harm in settling in an amicable settlement. Maintainability is, you have a point. It's not that you do not have a point. Heard Mr. So-and-so, learned counsel for the petitioner, comma, Mr. So-and-so, learned counsel for respondent number 1, 2, and 3, comma, Mr. So-and-so, learned counsel for the, very sorry, huh? I'm yet to learn your names. Learned counsel for the respondent number
4, 5, and 6.
4, 5, and 6, and Mr. Mayank Arora, learned counsel, Mr. Mayank.
Yes, your ladyship.
Respondent number 7. It is submitted by the learned counsel for the petitioner that a joint verification notice dated 16/2/2024 was issued by the revenue officers Kohima for assessment of the damages of the properties belonging to the petitioner.
Yes.
And after the assessment, there may be an amicable settlement, and an assessment will be conducted to assess the amount of damages, assess the amount of damages caused to the properties of the petitioner. The learned counsel for the respondent number 7 has submitted that the respondent was in no way involved in the respondent is in no way involved in this case. The learned counsel for the petitioner has also admitted that the respondent that the petitioner has no grievances against the respondent number 7, and his name may be deleted. And an application will be filed by the learned counsel for the respondent number 7 to struck off his name
Grateful.
from the area of respondents. The learned, so I'll not note down your submissions then.
My lord.
Better not note down your submissions. List the matter after 2-3 weeks. How many weeks? List the matter after 3 weeks, 4 weeks. List the matter after 4 weeks.
Obliged.
Obliged, your ladyship.
For hearing, item number 19.
This is the demands of the petitioner's limited lot with a very simple matter logic. For example, the petitioner, she's still serving as a medical attendant. It's a grade 4 post under the medical department logic. She was appointed in the year 2011 logic as a medical attendant on ad hoc basis logic. And she's still continuing in the same capacity. What if the grievance raised in this petition is that logic? In the year 2019, a vacant post arose. The post of peon, that is also an equivalent post, a grade 4 post. Now I guess a post that applied for considering my case for regularization. Now, instead of considering my application logic, the respondent number 5, the respondent number 5, she was considered. She was appointed. My sole contention in this petition law, I have only raising only 3 aspects as far as the legal principles are concerned. Both the petitioner as well as the private respondent, we are all temporary employees in the department law. My only contention is that if the respondents are to consider the private respondent number 5, the senior post has to be considered. That is my contention, the first contention. Lordship, it is an admitted fact that I was appointed in the year 2011 and I have completed 13 years as on leave. The private respondent number 5 was appointed in the year 2015, who is junior to me. If someone has to be picked from the temporary place, it has to be on the basis of severity compared. That is the first contention, legal principle. Lordship.
You were appointed on 2011
Lordship.
and
11.
R5 was on 2019.
15. So 4 years junior to me, Lordship. My contention is that if the department has to consider from the temporary employees, the principle of seniority cum merit has to be applied. That is my first contention. Second, Lordship, if the respondents, the state respondents or the departments takes a decision that they have to fill their post, it has to, and without considering the temporary employees, it has to be by way of regular selection process, but not by a stopgate arrangement or even otherwise, even in administrative exigencies. Then there's a clearly settled principle of law that the appointment has to be replaced only by truly regular selection process. Lordship, this is an admitted fact that there was no selection process in this case.
Okay.
That's the simple crux of the matter, Lordship. Now, if the Lordship kindly allow me that only three annexures, 3 documents to show the clear picture of how my appointment was made, as well as even the primary respondents, and how the primary respondent number 5 was considered for regulation. Only 3 documents.
All right. Yes, which page?
Page 12, Lordship. The Lordship go to page 12, annexure A, page 12.
Annexure 8, page 12.
Yes, Lord.
Yes, yes.
May I read it, Lord?
Yes.
This is an order dated 28 of February 2011, 28 of February 2011. In the interest of public service, humanity so the petitioner is temporarily appointed to the post of medical attendant on ad hoc basis for a period of 1 year under the establishment of Chief Medical Officer Kohima, in the scale of pay of so plus all other allowances as are admissible under the rules from time to time in Nagaland, immediate effect.
All right.
As per this order, Lord, will complete 13 years tomorrow, Lord. 13 years tomorrow. No, if the Lordship may kindly allow me to take the Lordship to page 28, Lordship. Page 28.
Page 28.
Page 28. This is the appointment of the private respondent number 5. Page 28. Annexure M.
Yes.
May I read it, Lordship? This is dated 26th of June 2015. In the interest of public service, ceremony so is hereby temporarily appointed to the post of beyond on ad hoc basis. The category of post is different. The nature of appointment is the same, Lordship. Under the Directorate of Health and Family Welfare National Framework, which we made it effect from so in the scale. For the extension of the service is subject to performance of the individual and as per the requirement of the department. This appointment does not guarantee for extension of service in future. Neither the right for claim of seniority or regularization. The appointment is purely on ad hoc basis and may be terminated 1 month notice of either side. So this document clearly shows that I was appointed in the year 2011 and the primary respondent was in the year 2015, 4 years after my appointment. Now coming to the Indian order, if you launch my kindly turn to page 27. 1 page forward the connection.
27?
27, Lord. 27.
Yes.
27. This is the Indian order. This is the order that we challenge this read by me. This is dated 4th of September 2019. 4th September 2019. In pursuance of the Government of Nagaland, Department of Health and Family Welfare, approval number so dated Shrimati so is hereby temporarily appointed to the post of office peon at CMO Kohima under the supervision of the Chief Medical Officer Kohima against the vacancy created due to the retirement of Very employee code number retired on 30th of April 2019. at level so all other admissible under the rules from time to time. The period rendered by the incumbent under ad hoc, it says, so she has rendered ad hoc service period from 26th of June 2015 will be counted towards the length of service for retirement as per Nagaland retirement from public service. All other service benefits and seniority shall be counted with effect from the date of regularization. However, qualifying lack of service for pension benefits shall be counted from with effect from the date of appointment of ad hoc basis, which means this is an order accommodating the private respondent on regular basis on the vacancy that was created on the retirement of a person. The appointment is purely temporary, may be terminated by 1 month's notice, given by either side on at any time without assigning any reason or will be covered by the terms and conditions of Nagaland government service rules and regulations. So this is the impute order that I have challenged with this petition.
Yes.
I have also raised my contention that my service should be considered in terms of a policy formulated by the state of Nagaland in the year 2015. However, the state respondent, by filing their affidavit, has contested that the OM has been put under challenge by way of a read petition bearing WPC number 145 of 2017. And as per the contention raised by the state respondents, they are of the opinion that that has been put under challenge, and it was quite set aside. That is the contention raised by the state respondents. Even otherwise, if the OM, the policy does not apply to the case of the petitioner, cannot also be applied to the respondents. I do not intend to go further with regard to the common policy logic, because there are certain principles of law as far as consideration of an ad hoc employee is concerned. My case is that, yes, there is already a precedent in the year 2006, Umadi's judgment, that bars from considering the employees for regularization. If that principle is applied, it should not be applied to the private respondent as well as the petitioner. Also, I'm facing a similar case where in the High Court of the Punjab and Haryana, it was decided in the year 2012, 6 years after Umadi's judgment was passed. It has discussed about Umadi's decision. Now, similar case, similar facts arose before the Honorable High Court of Punjab and Haryana, where the question of whether the private respondents should be considered or not, or whether the petitioners should also be considered under that existence scheme project. It is just a 3 pages judgment, if I may be allowed to read the judgment.
Yes.
Clarity. This is
So anyone is appearing for respondent number 5?
5 is already
Validated. I'm representing respondent.
Okay, yes.
Yes, file affidavit. I also file counter with the affidavit.
Please read the judgment.
Lodge. Prior in this read petition is to issue direction to the respondents to regularize the services of the petitioners. This is also a similar case from the date that juniors have been regularized, who have been imputed as respondent number 42199. Counsel for the petitioners contends that the claim and the case of the petitioners is similar to those of respondent numbers 42199. And therefore, the petitioners were entitled to the same benefit as has been granted to this private respondents, that is regularization of services, as per the policy which was prevalent at that time. Counsel contends that, as in the case of the private respondents, directions were issued by this court to consider a claim for regularization. In view of the policy of the government, similar was the direction issued by this court in the case of the petitioners in CWP number so-and-so, title so-and-so versus so-and-so. On the basis of this direction, respondent number 3 considered the case of the petitioners and finding the case to be covered by the policy, recommended the same to respondent number 2. The same recommendation was then accepted by the respondent number 3 in the light of the judgment of the Supreme Court. In the case of State of Karnataka versus Humani Logic, this case has been discussed. On rejection of the claim of the petitioners, they have approached this court with the prayer that, as in the case of persons junior to them, they should also be given the benefit of regularization. The respondents have filed the reply and taken the ground as has been so called out in the order rejecting the claim of the petitioners in the compliance with the direction of this court mentioned above. I have also heard the counsel for the parties in contrary report. Now, this is the observation. The factum of the petitioners having been appointed prior to the private respondents is not in dispute. the similar case, Lordship, it is not in dispute. It is also not in dispute that they are performing the same duties and responsibilities as are same as also the department. It is also not in dispute that the claim of the petitioners in compliance with the direction issued by this court in so and so was duly considered and recommended for regularization, but the claim has been rejected simply because of the judgment of the Supreme Court in Madhuri's case. The fact remains that the petitioners remained senior to the private respondents and therefore had a prior right to regularization, and the claim should have been considered in the same terms as in the case of the private respondents. The same having not been done, the petitioners have been discriminated against, and therefore the order rejecting the claim of the petitioners dated so and so cannot sustain it here when quashed. The petitioners are directed to be regularized in terms on the date their tenures were regularized and in the same terms.
Without the post?
No.
There has to be a vacant post also.
Yes, Lord. So, Lordship, after filing this petition, I have to seek instruction, or maybe the government advocate, they will be in a better position as to the vacancy position in the department. But till the time that this petition was filed, there was only one vacant post. Lordship, we have to wait for years and years altogether, Lordship, to accommodate our case, Lordship. Now, when a vacancy arises, after waiting for so many years, and if that vacancy has been considered by discriminating the senior most, Lordship, or the senior employees in the department, Lordship, there's a very clear case of discrimination, illegal action, and arbitrary action on the part of the respondents.
Yes.
Lordship understands if we wait for so many years, Lordship, and I don't know how long we will have to wait for.
So she was appointed in the year, respondent number 5 was regularized in the year?
2019.
Regularized in the year 2019.
She was appointed in the year 15 and she was regularized in the year 2019.
So she has been in service for more than 5 years now.
Lordship.
My lady, if I may please the court.
Hmm.
My lady, my submission will be very short and precise. As there is no dispute of fact with regard to the appointment, with the date of appointment.
No.
I've already been appointed.
Sorry for indulgence, Lordship, I have some other principles to be relied upon.
Yes,
after
yes,
my
yes.
concludes.
Yes.
My lady, as my learned friend has already apprised this court, I was already appointed as an office peon in the year 2015, June 2015.
Okay.
And when one post of office peon, one vacant post of office peon arose at the CMO Kohima due to the retirement of one Tenovicho Angami in the year 2019. I was considered by the department because I was already working as an office peon, and the vacancy which arose was the post of an office peon. That's
So this post under which she was working, the petitioner, it's a post of
medical
attendant.
attendant.
So attendant is below office peon.
No, my lady, both medical attendant as well as the office peon belongs to the same grade 4. But even though they fall under the same category, that is grade 4, their designation is different, and they also discharge different duties. They have different assignments, my lady. So when this vacant post arose of one office peon arose, even the petitioner as well as some other applicants, along with the respondent 5 hearing, we have all applied for the post. And then after due consideration by the department, I was appointed. And then my ad hoc post was made regularized in the year 2019 because of the fact that I was already working as an office peon. And then the vacancy was that of an office peon. My lady, on the second contention that my learned friends have recently submitted is that they are claiming that the petitioner is a senior most. However, when we go through that annexure that they have annexed in their own writ petition. If my lady, I can take you to page 13. Page 13 of the writ petition. It is the first extension order of the petitioner hearing.
Yes.
Yes, my lady, I will take you to the relevant para, that is paragraph number 2. Further extension of the service is subject to performance of individual and as per requirement, the department, as per requirement of the department. The appointment do not guarantee for extension of service in future, neither the right to claim seniority nor regularization. So, my lady, every time the department gives extension to its ad hoc employees, this is the pattern, this is the wording
So
they
this
have
is
used.
page number 13.
Page number 13 of the writ petition,
Ah.
the second paragraph. So here, every time the ad hoc employees of this department are given extension of their service, they are given only after 1 day break, so that there is no continuous
Yes, yes.
continuity of the
1 day
service.
break is given.
Yes.
Do not guarantee for extension of service in future. Neither.
Yes.
Yes, 1 day break is always given. Which
So
we
there
have-
is no seniority list maintained for the ad hoc employees. So their claim of being the senior most is misleading and misconceived. My learned friend, he has also relied on the OM, 2015 OM, which is in para 10. Para 10 of the writ petition. As per the OM, if I may be allowed to read, my lady. It's in page 8 of the writ petition.
Page
Page 8 of the writ petition, paragraph 10.
relating to the OM,
Yes, my lady.
OM 2016. OM,
They have made the extract in the paragraph 10 of the OM.
yes.
The actual OM is annexed in the annexure O.
Yes, annexure, oh,
Annexure O, page 31. However, they have already put up an extract of
yes.
the OM. I'll read the relevant paragraph.
Mm. Mm. All right, you complete the paragraph, then we'll take a break.
Yes, my lady. I'll read only the
Last minute. Last minute petition. Yes, yes.
Thank you, my lady. My lady, I'll read only the relevant paragraph. As per this department office memorandum, contract employees who have completed more than 3 years of continuous service on contract/ad hoc basis will be eligible for regularization against sanctioned posts, and a suitability test should be conducted by the concerned departments under the chairmanship of the head of the administrative department with PNAR department and ATI Nagaland Kohima. So they are relying on this OM. However, there is no continuity of service. So even relying on this OM is not applicable.
All right.
Maybe we will continue after the break in that case.
Yes, you can call her.
Bas ya mama bilang kamu tuh dia kata ini kok ke sini lah macam begitu ini ke sini aku Oh, 1919 I may be allowed to continue.
Yes.
Yes, my lady, so, the petitioner herself has applied for the vacant post of office peon. And only after when when the respondent number 5 has been selected, the petitioner is here before the court. Well, she herself has also applied in the earlier instance for the vacant post. But as stated earlier, since the vacant post is that of an office peon, and that I was previously engaged as an office peon, my selection has been done by the department after considering all the options from the various candidates. So, the claim of the petitioner to be the senior most adult contract employee in the department is not found. The 2015 ON that the petitioner is relying on is not applicable for one-off continuous service. So here, as such, the petitioner has no longer standing to file this instant writ.
Yes.
That will be my humble submission.
Yes, yes. Yes. Yes, government, no?
Yes, Your Lordship, for the state, Your Lordship. The Lordship here, the petitioner is claiming that she is the senior most, but that is misconceived, Your Lordship. Till now, the seniority list is under compilation. It's not out. It has not been notified. So the contention of the petitioner cannot be sustained, Your Lordship. Now, Your Lordship, regarding the memorandum which the petitioner has relied, Your Lordship, that has been set aside by this court, Your Lordship. So, Your Lordship, that OM is irrelevant, Your Lordship.
It has been set aside.
Yes, Your Lordship, that we have filed in our affidavit also. Your Lordship, the judgment, Your Lordship, which the petitioner has relied also is irrelevant because until the seniority list is out, Your Lordship, that judgment cannot be applied, Your Lordship. Now, regarding the appointment of the private respondent, Your Lordship, application has been invited, Your Lordship, not through open advertisement, Your Lordship, that we admit, but even the petitioner is one of the applicant, Your Lordship. If Your Lordship may kindly see my affidavit in opposition, Your Lordship will see the name of the applicant, which has been forwarded to the government for approval, Your Lordship. Page 7 of my affidavit in opposition. Serial number 5 is the name of the petitioner, Your Lordship. Page 7 of my affidavit in opposition.
All right.
Yes, Your Lordship.
Okay. Serial number?
Serial number 7, Srimati Kevini Sino, Your Lordship. So this, your lordship, had notes details of 10 applicants applying for the post of office peon at CMO Kohima against Srimati Thenuvicho Angami, who retired on 30/04/2019. Your lordship, this vacant post is in question, your lordship. So here, even the petitioner's name has been forwarded to the government. Your lordship, but the approval has been given to the private respondent. That is the decision of the government. Now, your lordship, if at all this writ petition is maintainable, then your lordship, the petitioner has to challenge the decision of the government. That is not under challenge, your lordship. So on that ground alone, your lordship, this writ petition cannot sustain, your lordship. Now, your lordship, the other issues, whether on the issue of advertisement, your lordship, there is one OM, though this OM has not been followed, your lordship, there is an OM where advertisement has been suspended, your lordship. OM, if I may be allowed to refer to that OM. OM dated 3rd of March, 2022, your lordship.
You have not annexed this with yet?
No, your lordship, because this has not been followed, but still there is an office memo, that's why, just for your lordship. Yes, your lordship.
All right.
May I read, your lordship? The post in question is regarding this group D post. It's a grade 4 post, your lordship. So it's this OM applies to the post in question, your lordship. Filling up of grade D post in the department's horizontal issued register. The procedure of filling up grade 4 posts in the government has been laid down by Office Memorandum dated 26/10/2017 and 24/3/2018. The latter memorandum lays down that application for recruitment to the post should be called through open advertisement. Following difficulties expressed by various departments on account of the fact that in many cases, Group B posts such as Jokidar, Malis, and peons, your lordship, are filled by landowners or on compassionate ground and locally at the district, subdivision, or village level. The matter was considered by the cabinet in its meeting held on the 9th February 2022 and 22nd February 2022. In order to remove such difficulties, it is hereby directed that the condition of advertisement is dispensed with wherever such difficulties are faced by a department, as long as a fair and transparent eligibility criteria and process is followed. And in all such cases, approval of the government is obtained. So, your lordship, here the appointment of the private respondent was done on the approval of the government, your lordship. So it is in tune with this OM and your lordship. Therefore, your lordship, even if advertisement is not done, your lordship, there is nothing wrong with the approval order, so long as the approval order is not under challenge, your lordship. So, your lordship, on that ground, this repetition is not maintained, your lordship. Yes, your lordship, that's all.
If I may note. The states as well as the parties on the visit. They have raised the contention that firstly on my locus, locus step and the senior most. What has been submitted by the Contempt state law that they are in the process of compiling the senior list. Assuming lordship done at the senior most, in order to establish my locus lordship, the document which was produced by the state respondents showing the list of applicants. Now I have also submitted my application and they have compiled a list that includes 10 applicants. Now that shows that I was also part and parcel of that process where, of course, there was no selection process, but they have considered basing on the recommendation of different member of the Legislative Assembly Lodge, and also on other different considerations.
The application was forwarded to the government.
Lodge. Now, Lodge, the administrative approval as well as the OM Lodge, The administrative approval, the strength of getting that source, Lordship, the source of getting the administrative approval as well as the office memorandum. It is framed under the Article 167. Lordship, now whether the administrative instruction can override the fundamental rights. Article 14 and 16, Lordship. Article 14 and 16. And Lordship, there are also numerous precedents.
Judgments, yes.
Lordship, whether Article 14 and 16 can be override by a mere administrative instruction, Lordship. Article 14 and 16 says equality of opportunity, 16 equality of opportunity for appointment, Lordship. Whether by
So she has raised the point, why didn't you challenge the government order?
Lordship, the intention, Lordship, the intention is in the decision of the government. Whereas, Lordship, the outcome is by the way of the order. So I have challenged the order, Lordship. I have challenged the order. The final outcome is the regularization of the private respondent in the year 2019. There was, of course, a decision by the government to appoint the private respondent. That decision, it came by way of an order in the year 2019. That's how the private respondent was accommodated. Now, applying the principle, Lordship, of constitutional scheme for public employment, Lordship. It is a constitutional mandate, Lordship. Article 14 and 16. Now, if the respondents carry on with such kind of practices by accommodating without any regular selection process, Lordship, that is also a way of appointing respondents. Rightly observed by Umanimi, Lordship. Regularization or appointment without selection process cannot be a way of appointment, Lordship. And that is exactly the case of the private respondent. They cannot be accommodated. It can be only by way of a regular selection process. Lordship, we not to support my argument, Lordship. If I may be allowed, it's a celebrated judgment, Lordship, that very well settled principle of law. Minus 6 case, Lordship, 1992, Volume 4, SCC 118. I read only one paragraph, Lordship. That rules, it is a paragraph that explains about how temporary employees can be replaced, Lordship.
Paragraph?
Paragraph 45, Lordship. 45. Not to find it, page 152. 152.
Can you download this judgment later?
99.
Paragraph
45.
Paragraph 45.
I'll be relying on 45.
Yes, please read.
The normal rule, of course, is regular recruitment. That is exactly the opening line of the paragraph. Paragraph 45, page 152. 152. The normal rule, of course, is regular recruitment to the prescribed agency, but exigencies of administration may sometimes call for ad hoc or temporary appointment to be made. They have not stated that there is administrative exigency, Lordship. It is not an administrative exigency situation, Lordship, in this case. They have not stated, they have filed the affidavit, they are silent on that, Lordship. In such a situation, effort should always be to replace such an ad hoc temporary employee by a regularly selected employee as early as possible, not by this kind of arrangement, Lordship, which the respondent has done. Such a temporary employee may also compete along with others for such regular selection appointment, Lordship. If he gets selected, well and good, but if he does not, he must give way to the regularly selected candidate. The appointment of the regularly selected candidate cannot be withheld or kept in abeyance for the sake of such an ad hoc or temporary employee, Lordship. Paragraph 56. Secondly, ad hoc or temporary employee should not be replaced by another ad hoc or temporary employee. This is the standard principle of law, Lordship. He must be replaced only by a regularly selected employee. This is necessary to avoid arbitrary action on the part of the appointing authority.
Yes, you have a point. But suppose
Lordship.
There's a decision that this respondent number 5 is wrongly selected. Suppose if there's
Lordship.
So where is the post? Where is the vacancy?
Lordship, the vacancy held by the private respondent, Lordship. He was appointed, Lordship.
She's already working for 5 years now.
Lordship, no doubt, no doubt. Lordship knows very well about the observation of Madi's case, Lordship. more than 10 years, only more than 10 years. There is no remedy, there is no rescue for illegal action law. Lordship knows very well. This is blatantly an illegal action law. What can be more than that, Lordship? And if this is allowed to perpetuate, Lordship, where will I get justice? And before the temple of justice, Lordship. If this court on the forward do not interfere on the appointment of the private respondent, Lordship, now the authorities will continue appointing illegal appointments, Lordship. They will continue to do that. If this is not what it says. Lordship, for all fairness, if I may be allowed to make a suspicion. Of course, Lordship, it is my prayer that I success.
So she has not placed it on record, but there's an office memorandum also,
Lordship, that is
which does not render this illegal.
That is what my submission is. Whether this office memorandum can overrule the precedents
Yes.
by the Supreme Court, Lordship. It is a mere paper, Lordship.
All right.
Executive instruction, Lordship. How can they override the precedent? And this is the judgment of Supreme Court under Article 141, Lordship. This is binding on all the courts all over the country. How can a mere administrative instruction override the precedent of the Honorable Supreme Court of India, Lordship? It is binding on all the courts for the sake of repetition, Lordship. Now, for all fairness, Lordship, yes, of course, it is my prayer that I should be considered for regularization. But Lordship, for all fairness, if this post can be advertised, remove the private respondent, Lordship, since it's illegal appointment.
That you have not mentioned in the petition. Have you mentioned?
Lordship, my prayer is to consider me for regularization, but for all fairness, Lordship, this court sitting under Article 226 has the ample jurisdiction to do that, Lordship. This court is sitting under Article 226. Lordship. And for all fairness, can be advertised. I can participate, and the private respondent will also participate. And if the eligible, the most eligible candidate will be selected. For all fairness, Lordship. Otherwise, my prayer.
Only the remedy is to set aside and quash the order,
Yes, Lordship.
appointing the private respondent, according to you.
Yes, Lordship. And it can be advertised for all fairness. Otherwise, my prayer is to consider my case. But it has been disputed, the seniority position has been disputed, and my learned friend Gohman advocate has made a submission that they are in the process of compiling the seniority list. So it depends, my destiny depends on the outcome of the seniority list. They have disputed my seniority position, Lordship. So now I cannot go beyond the record. And the government is the custodian of all the reports, so I cannot go beyond that. So for all fairness, if the private respondent appointment can be questioned set aside and a direction may be issued, Lordship. And that has been done in so many cases. Kind of decisions are there. That is my respectful submission.
My lady, if I may make a small intervention in that. As far as participation is goes, both the respondent respondent number 5 as well as the petitioner hearing, they have both applied. So their participation has already been considered by the government.
All right, then we'll conclude. I'll pass an order later. If I can complete, then I'll complete it, and if not, then I'll reserve it for delivery of order.
Lordship. Much obliged.
Much obliged.
So let me find out if I can finish it during the day, and if not, then I'll reserve it for SAB. Or maybe day after tomorrow, or also I can fix it. Then I'll dictate the journal day after tomorrow. I'll need this judgment. Copy of this. I won't take the book from the library. You can get a copy, no? From the library or something. You can get a printout from the library, no? And I'll leave the names.
Written down the names.
Yes, yes. And item also, this is at the stage of hearing, no?
Stage of
The stage, then names of the parties representing who move, and then so that it won't be very difficult for me. Or if you can give this to me. No, you mention the names separately.
Okay.
You got a printout with that?
Okay. Itu dia print guna tu muya terakhir kita boleh itu nak guna lagi nanti stage. We got the names. Names. You want to write down the names? Right now.